Chapter 2, Exemption from Taxation of Property Used for Educational Purposes. 1. Rules of Construction. The property belonging to the state or other civil divisions, employed for the purpose of public education, is, like all other public property, exempt from taxation. And property devoted to educational purposes, generally, is expressly exempted from taxation by legislative enactment in the various states. The statutes of some of the states are, however, much more liberal than those of others, and questions frequently arise as to the extent of the exemption and the construction to be given thereto. It is said that taxation is the rule and exemption the exception, and that statutes providing for exemption should be strictly construed, so that no property shall be exempt excepting that which is clearly and fairly within the express terms of the law. The right of exemption cannot be implied, but must be given in language which will not admit of doubt. Exemptions are so repugnant to the law that they will be construed with strictness. Statutory exemptions will be construed as a direction not to assess, rather than as a contract creating vested rights. When an exemption is prescribed as part of a charter granted by the state to a corporation, such exemption becomes part of the contract, and is protected by the Constitution of the United States. This is well settled. 2. Whether property must be actually used for educational purposes. Whether, in order to be exempt, the property must be actually used for educational purposes, depends upon the wording of the particular statute creating the exemption. But the judicial constructions which have been put upon such statutes as have been called in question are valuable aids in discovering the meaning of analogous laws. In order to be exempt from taxation, it is generally necessary that the property be actually used for educational purposes. But it was decided by the Supreme Court of the United States that an exemption of all property necessary for school purposes includes property not in actual use by the school, but which is rented and the income applied to the support of the school. And under a statute of Massachusetts exempting from taxation the personal property of literary and scientific institutions incorporated within the Commonwealth, and the real estate belonging to such institutions occupied by them or their officers for the purposes for which they were incorporated, it was held that a farm used for pasture and tillage grounds, the products of which were used for the support of a boarding house for students attending an academy, was exempt. A certain building was at first intended for a dwelling house, but the plan was altered soon after the foundation was laid, and the owner, under an agreement with another, finished it for use as a seminary, and it was so used, under a statute exempting every building erected for the use of a college, etc. It was held that this building was exempt. 3. Residences of professors, etc. It has sometimes been made a question whether the residences of college officers and professors are included in an exemption of property devoted to educational purposes. In New Jersey it is held that the exemption clause in the Tax Act of that state of 1851, exempting all colleges, academies, or seminaries of learning, extends to the houses and lots provided by the College of New Jersey for the residences of its president, professors, and steward, such residences being in part pay for their official services. Under the Iowa statute exempting from taxation all public libraries, grounds, and buildings of literary, scientific, benevolent, agricultural, and religious institutions and societies devoted solely to the appropriate objects of these institutions, not exceeding 640 acres, and not leased or otherwise used with a view to pecuniary profit, it was held that all property, including the residences of professors upon the grounds of literary institutions and the dwellings of clergymen owned by religious societies and used, exclusively for such dwellings, without pecuniary profit to the owners, is exempt from taxation, provided such property is proper and appropriate to effectuate the objects of such institutions. The presidents and fellows of Harvard College built a dwelling house on land of the corporation within the college yard, and leased the same to one of their professors, to be occupied by him as a residence for himself and family at an annual rent. Held, that this was not an occupation of the real estate of the college by one of its officers, within the exemption from taxation provided by Massachusetts Revised Statutes, ch. 7, Section 5, cl. 2, but it was expressly stated that this would be otherwise if the building had been built for one of the professors or officers of the college, and had been occupied by him, with the permission of the college, and without having any estate therein, or paying any rent therefor. But in Ohio it was said the mere occupancy of a house by a college professor is not an occupation for literary purposes, within the meaning of certain acts of 1831 and 1834, although it is situated on land of the college. Under said acts the building must be occupied for literary purposes. 4. Property of private schools and of private persons. These exemptions are not generally intended to include private schools operated for individual profit, nor property used for the support of such private institutions. A building used in part for school purposes and in part for other purposes is not exempt, because there can be no separate assessment for the part not used for school purposes. A private boarding school is not such a school or seminary of learning as is exempt from taxation by 1 New York Revised Statutes, 388, Section 4. A building owned by the College of New Jersey, but used as a grammar school, at an annual rent, and which prepares students for the college, is not such a part of the college as to be exempt from taxation. A grammar school kept by a person at his own risk, on his own account, is not exempt under the New Jersey Tax Act of 1851. And in Illinois it has been decided that to constitute a schoolhouse a public schoolhouse, and to exempt it as such from taxation, it must be property under the immediate control of the school district. But in Indiana, under an act of 1861, it was held that buildings erected, kept, and appropriated for the use of a literary and scientific institution, and in which a corps of teachers has been engaged in instructing pupils in ancient and modern languages, in the various sciences, and in all branches usually taught in colleges, are exempt, even though the institution is conducted on private account, and the earnings go to the individual proprietor. In Louisiana it is decided that a building is not exempt because used for a school, unless its owner keeps the school. If its owner rents the building, and thus derives an income from it, the building is taxable, notwithstanding it is used for a school. In Michigan, under a statute exempting from taxation certain real estate belonging to library and benevolent institutions, it was said that the words belonging to do not necessarily imply ownership, unless upon the most severe technical construction, for property belongs to its possessor so long as he has the exclusive right to its possession.